Okay, now when we're talking about dealing with companies or entities outside of our own organization, obviously there are privacy considerations that we need to be aware of, and we need to make sure that we have a privacy policy that is in place and enforced. Again, we want to ensure that our data is secure. We also want to make sure that we don't unintentionally leak out someone else's data. So we need to have these things put in place. Again, a lot of these things in this particular module are more conceptual. We're just trying to talk about some terms that you need to be aware of, and the fact that privacy considerations kind of permeate through everything that we do when we set up these types of agreements. We also need to be aware of the various risks that are involved. And we talked about evaluating risk and vulnerabilities and threats and so forth in our previous module, so I'm not going to cover it too much here, but just understand that the same types of risks, the evaluations, the qualitative versus quantitative, and all the things that kind of surround how we will identify and analyze things internally, those things also need to be applied when we're dealing with outside companies, when we're doing these third-party integrations. All right, so just kind of be aware of these concepts. And then the unauthorized data sharing or data access policies kind of go hand in hand with our privacy policy, and they are part of our risk awareness. We need to make sure that we understand there is a risk that there will be unauthorized data shared by our third party. All right, by our third-party engagement, I should say. So we need to understand that it is important, it's really in our best interest and also for the other company's best interest to have these things in place, these agreed-upon codes of conduct, our SLAs, right, our service level agreements. They need to be in place beforehand, before the engagement begins. And then we have our data encryption policies, granular access controls so that we define very specifically who can access what, for how long, right? We don't want to give too much access. And we also want to make sure we have a detailed monitoring process defined and in place, because as we'll learn, when you monitor things, typically they improve. And even if they don't improve, you're monitoring them, so you're going to know that, right? So you're going to be able to pick it up and raise the bar, so to speak. So all of these things have to be in place, and we have to make sure that we're approaching them with a very kind of methodical mindset. All right, now as far as data ownership, well, who owns the data? As we talked about, if we have a joint venture or a third-party relationship, do they own the data? Do we own the data? If we create data kind of conjoined, do we both own it? Okay, one or the other, et cetera, et cetera. It needs to be defined. If they're accessing our data, do they all of a sudden own it or have access to it or have ownership rights to it now that they've accessed it? Okay, maybe, maybe not. It needs to be defined. Does the original creator or the processor retain ownership indefinitely? Or again, as I said, if it's transferred to other parties or the receiver, do they now have ownership? So if that's not defined, then that's up for grabs. Okay, it's up for interpretation, and you open yourself up to possible litigation because it's not clearly defined and agreed upon before the engagement begins. And again, do intermediary or third-party entities over which the data passed. Okay, so if you have a third-party colo data center or maybe a clearinghouse or a data warehouse, if the data is stored there or passed through there to another kind of final landing spot, does that intermediary party have any rights or any claim to that data? So again, these are all things that need to be defined, and the more you have defined and the more thought up front, then the less you have to worry about as far as from a litigation or misunderstanding or misinterpretation point after the fact.